They do it because they can, they won't if they can't. This is true of life and regulatory and employment law. They won't if they can't. So it's up to us to take action. If we're passive, nothing comes from nothing, but something might come from something. In general, some of the actions I recommend and support people with are appeals. Appeals can be within the employment framework, outside of it. Appealing within a system that's dysfunctional is not usually a good idea or successful, but it can be useful to show evidence that we've done everything reasonable. It's much better to go outside of the dysfunctional organisation, whether it's the regulator or the employer or somebody else, and especially appealing in the High Court in the UK is very useful. Many people have fear of the law, and yet they're dealing with complex medical situations that are far more intricate than the legal processes and systems. Yes, it's unfamiliar, but we could become familiar by picking up a book, reading it, learning a little about the law. Very simply, we have rights if we stand up for them. We don't have those rights if we don't stand up for them. So, for example, if the regulator is not doing a fair process, one can apply to the High Court even before the regulator's made a judgment. So yes, we can appeal their judgment, a determination, at the end of a hearing, but along the way the journey could be several years, and it's good to challenge them during that time because they may behave a bit better or they may not, but ultimately we're going to get a decision from a court which hopefully is more fair-minded. It has to test and weigh evidence and see what is credible and which witnesses they believe, but they need evidence for everything. Whereas in the employment and regulatory kind of kangaroo courts, they tend to be persuaded a lot more by the prosecution. They're fed by the prosecution, they're paid by the prosecution. Even the expert witnesses, there's one company I've dealt with have £6 million from the regulator in the UK, so they have a vested interest in writing reports that please their client. And yet there's an obligation really for expert witnesses to write a fair report by getting information from both or more parties, all parties. I know this because I work as an expert witness, and it's simple common sense and reasonableness. You cannot write a report that's, of course it's biased if it's just one party giving their information. So expert witnesses have legal liability now. It's been demonstrated in the courts many times in recent years. Prior to that, they were very much protected. Now they do have a responsibility and a liability to write fair, reasonable, balanced, accurate reports. So if you've had an expert witness report against you that's unfair and biased and unbalanced, you can actually sue the author of the report, and if it's a company, sue the company. And again, when I say sue or any legal action, it can be relatively simple. Filling in a form, putting what the facts are, ticking the box that says it involves human rights actions. Those human rights actions tend to be breached are the right to fair process, Article 6, Article 8, the right to private and family life, and Article 14, the right not to be discriminated against. And interestingly, healthcare practitioners, particularly who raise safety concerns, are whistleblowers. That's a protected disclosure, and then they may be treated less favourably. That's a form of discrimination. So in summary, it's 3 words: action, action, yeah, you know it, action.